Good morning. Happy Friday, everyone. Welcome to our second day of Joint Judiciary. Carissa, I'll call the roll.
Mr. Chairman, this is roll call for the Joint Judiciary Committee for November 8th. Senator Case. Senator Cooper. Senator Furphy.
Here.
Senator Schuler. Representative Chestick. Representative Crago. Representative Haraldson. Representative Jennings. Representative Nemec. Representative Oakley. Representative Provenza. Representative Rodriguez-Williams. Co-Chairman Landon. Chairman Washut.
Here.
All are present.
Mr. Co-Chairman, any comments this morning?
Well, Mr. Chairman, I just wanted to tip my hat to the committee. Yesterday, I thought we did some good work. There's miles to go before we sleep, but I thought we set a pretty good foundation with some of those bills, and want to thank the committee. I want to thank everyone who was patient and stayed with us through the day. Sometimes it takes a little while to make these laws, but anyway, take it away, Mr. Chairman.
All right, we will get right at it this morning. First up on our agenda is protection orders and 25 LSO 283.4. Mr. Fuller?
Yep, and Mr. Chairman, 10-01 in the online meeting materials. This is a bill draft that the committee requested in September. The motion was for a draft based on Montana's law for permanent protection orders, and that's what this does. This draft would establish a process for the granting of permanent protection orders. So on page 2, line 4, this is a new statute in the sexual assault protection order statute to provide for a permanent order of protection. So the court may, upon petition by a victim or a person specified in 73507A, that would be the district attorney, a person with legal authority if a minor, vulnerable adult, or someone if that person for some reason cannot file. The court may enter a permanent order of protection or extend an order that's previously issued on a permanent basis. A permanent order that is issued would order the respondent to refrain from any conduct or further acts of stalking or sexual assault involving the victim or any other person. Before entering a permanent order of protection, the court must, and this is page 2, line 14, and this is really the standard, consider the respondent's history of violence, the severity of the offense at issue, and any evidence presented. And then on line 18, determine that to avoid further injury or harm to the victim needs permanent protection. And that's the standard that Montana uses. The staff comment on page 3 just compares that standard with what Wyoming has for both temporary orders and then the orders that can be entered for up to 3 years. So that's just a comparison for the committee to look at. The different standards that are presented in this bill for a permanent order versus what is currently required under Wyoming law. So for example, a temporary order for sexual assault or stalking would require the court to determine from specific facts that there exists a clear and present danger of further stalking, sexual assault, or of serious physical adverse consequences to any person. For that sexual assault or stalking order, the court must find that conduct constituting stalking or sexual assault has been committed. And then similarly for domestic violence orders, the temporary one must appear from the specific facts that there exists a danger of further domestic abuse, and then that up to 3-year order would require the court to find that an act of domestic abuse has occurred. Then page 3, line 33, the court may, in any permanent order of protection, specify any of the directions or conditions in 73509A. And that's existing law. That would include things like orders or direction to stay away from the home, school, or business of the victim or any other specific locations, refrain from contacting, intimidating, threatening, or otherwise interfering with the victim. Page 3, line 37 requires a permanent order of protection to include the notice that's required under current law, and that notice is that a willful violation of the protection order constitutes a crime and can result in immediate arrest and potentially enhanced penalties. Then page 3, line 38, moving on to the top of page 4, a hearing must be held before a permanent order is entered, and the petitioner or another party may move to appear remotely as is provided under current law. Page 4, line 6, and this is another kind of carryover from Montana law. And it specifies that a permanent order of protection may be terminated upon the victim's request that the order be dismissed. The staff comment on page 4 just notes whether the committee may wish to consider other instances or situations in which a permanent order may be dismissed, whether that involves a motion from the respondent or the subject of that order, for example. Then page 4, line 26, basically provides the same process for domestic violence orders for a permanent order of protection under that act. The language is quite similar, and Mr. Chairman, unless there's a specific need, I won't go through those provisions line by line. They're virtually the same as is provided in the previous section that's new. Then, Mr. Chairman, the remainder of the bill draft, starting on page 6, are mostly conforming amendments to reference the new statutes that have been created in this bill draft. So starting on page 6 are conforming amendments to the stalking and sexual assault protective orders. The one thing I would note is on page 9, beginning with line 3, and this is the language in the sexual assault and stalking orders concerning the tolling of that 3-year protection order if someone is sentenced or and incarcerated during the active period of that order. All of that language is stricken from this bill draft. Then similarly, Mr. Chairman, moving on to beginning on the top of page 12 are conforming amendments to the domestic violence protection statutes. And similarly, on page 12, line 14, the language concerning the tolling of those DV orders is stricken as well. Page 13, line 16 is applicability. So nothing in the act is construed to alter, amend, or abrogate any order of protection that's entered before the effective date of this act. And then orders of protection that are currently tolled as of July 1, 2025 would remain tolled and would proceed under the current law as it existed before it's stricken from this bill draft for those specific orders. With that, Mr. Chairman, happy to answer questions.
Committee, any questions for Mr. Fuller? Seeing none, thank you very much. Very informative paper. And we have some witnesses in the room that wish to testify. Ms. Chambers? Okay, we're going to bring the whole team up. That works.
Good morning, committee. My name is Kara Chambers. I'm the Director of the Division of Victim Services at the Wyoming Attorney General's Office. I am really here just to answer any questions you may have. I think we discussed this at the meeting in Cheyenne, and I believe Mr. Fuller has done a fine job of walking you through it. So if there's any questions, I'm here with my compatriots as well, who are also just here to answer questions, I suppose.
Okay. Why don't we get everybody introduced for the record, then we'll see if the committee has questions.
Mr. Chairman, members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch.
Mr. Chairman, committee members, my name is Dan Shannon. I'm with the Wyoming Department of Corrections.
Do either of you have any comments you'd like to make?
Mr. Chairman, committee, after reviewing the proposed legislation, it's my understanding this proposed legislation allows the protection order to remain while those are incarcerated. So I don't really have a concern. I think it's actually a benefit.
Committee, any questions? Representative Harrelson.
Thank you, Mr. Chairman. Thank you guys for coming out, and Director as well. The only question I have, first of all, I like the concept, because as I've worked with these situations, there are times where you're like, oh no, we're going back in to try to protect again. But I also, as a pastor, I also sit there and go, I have seen people change. So what is the mechanism if someone were to, obviously this is in the victim's court of decision, but if they were to sit there and say, you know what, things have changed, what is the course of action now to get a permanent not be permanent? Is there a way, and what does that look like?
Ms. Butler.
Go ahead.
Mr. Chairman, Representative Harrelson, I think as of today, right, the way the law stands today, not with this bill, there is no opportunity for a permanent protection order. This bill would allow, under that permanent protection order statute, would allow for the victim to petition the court to end the protection order. Currently, I think there's a staff comment in there, Mr. Chairman, that talks about on page 4 whether or not the committee would like to consider an opportunity for the respondent to petition for the ending of that protection order as well. It's not currently in the bill, but that is the staff comment that you have in your bill.
Follow up? You good, Representative?
Chairman? If I
Ms.
may.
Chambers.
Thank you, Chairman. Representative Harrelson, I would like to point out that currently a respondent can bring a motion to modify or to terminate as is under law. But I agree with the staff comment if that's something that you would like to codify.
Mr. Chairman, thank you. And I was referring to that because I saw that comment and I was like, okay, so this is obviously another mechanism in there. So no, I just wanted to kind of get an idea of what that mechanism should look like and your guys' heart on that. So I guess the question I'll throw into this is, on that staff comment, and I'll ask the panel, what's your heart? Do you believe that would be good to add that in as another mechanism that the courts would have say in this?
Comments on the staff comment?
Mr. Chairman, members of the committee, I would say overall on this bill, every part of this bill is a policy question, right, for you all to consider. So from the standpoint of the judiciary, we don't take, we don't take a stand on the bill, whether or not it should be approved or not, because that is a policy question. And again, I'm not sure that I have strong feelings one way or the other on whether the respondent should have that opportunity. Again, I think that's a policy question for you all to answer.
Senator Case.
Thank you very much, Mr. Chairman. I think I have kind of a stupid question, but in terms of these protection orders, it seems to me that one likely occurrence is that the victim and the other person reconcile in some way. And I'm just good or bad, whatever. And then the protection order still exists. Then, of course, the respondent or the defendant is still under that protection order. It's still legally binding. And then what happens in those circumstances? And does it occur that the victim sometimes will seek release of the protection order? And I don't know about these things. Thank you. I hope that's not stupid.
Ms. Butler.
Mr. Chairman, Senator Case, it's absolutely true that there are often times when a victim of domestic violence or violence of some sort who has a protection order and the respondent will rectify and get back together. That happens often. The victim does have the opportunity to petition to terminate, as does the respondent, I believe, currently. I would say if the protection order was still in place at the time when they do rectify and they don't take any action, you're absolutely right. That protection order still has legal effect. And there would be a risk of prosecution in some circumstances, depending on, whether or not the prosecutor's office wanted to bring a charge like that. But there is that possibility.
Further questions? Director, does this solve the problem that we were hoping to solve with regard to tolling?
Regarding the tolling, Mr. Chairman, yes, regarding tolling, because it'll remain while they're incarcerated. Yes.
All right. No further go. Representative Oakley.
Thank you, Mr. Chairman. I'm wondering specifically, Director Chambers, if you have experience with these from in place in other states, and because specifically what I'm interested in is the upon good clause, which we got a good staff comment about, but about the defendant or respondent having it removed. And so just generally, is this something you have experience with, like in that specifically, or any of these, like how working, in the real world, if you will?
Ms. Chambers.
Chairman, Representative Oakley. Yes, so as we discussed and Ms. Butler pointed out, there already are provisions in the law for a respondent to bring a motion to try to terminate. And in the circumstances where there's an active order and the respondent is violated and brought to court, there is already in the law an affirmative defense that the victim compelled the respondent to violate, basically. And so that already exists in the law. Does that happen? Yes. I have seen judges who, well, I've been in states where they could have cross petitions. And so it was sort of a mutual, you stay away from them and they stay away from you kind of situation. Yeah, it's not uncommon for parties to reconcile. Like I said, there already is a mechanism under the law for a respondent to try to get this modified and maybe bring evidence of the victim coercing violation or, not even honoring, the sort of standards. I've been in courts where judges have admonished the respondent, I don't care if she makes your favorite meal, if she does this, you don't violate, because regardless of what the petitioner is asking. But like I said, there already is law that the respondent can bring that defense. Yes, in Wyoming law, yes.
So, Ms. Chambers, if you know,
I can't.
all of these people who might be subject to a permanent protection order under this bill draft, are they already prohibited persons under federal law for firearms possession? And I guess my concern is if we make this permanent and it just remains in effect out of lack of attention or concern, this individual continues on being a prohibited person because of the protection order. But did the conviction that led to the protection order, or is there always a conviction that precedes the protection order?
Chairman Washit, so to answer your first question, for a person to be a disqualified person under federal law, there are a variety of conditions, including being a convicted felon, so any crime that would be a felony, but any misdemeanor domestic violent act. And so that covers not just misdemeanor assaults, but maybe unlawful contact if they look at the relationship between the parties. So if there had already been a conviction of one of those, either a felony or a misdemeanor domestic violence, then it's moot. The protection order isn't the reason they don't have their weapon, if that makes sense. Now, could you have a situation where I don't think, based on the language of the statute, that you're looking at the history of violations, and I don't know that that's, because on page 2, line 14, Roman numeral I, you have to consider the respondent's history of violence, the severity of the offense at issue, and the evidence presented. I think, to me, that sort of reads like this wouldn't be a situation where the protection order is the only thing prohibiting that person from from obtaining a firearm or being a prohibited person on the federal level, if that makes sense. I suppose there's a scenario, but I don't know that those would be the petitioners who are likely to obtain a permanent protection order, because remember, we're not undoing the current protection order, which is 1 to 3 years. And I think those are the folks who might be eligible for that. I really see this statute protecting these, really the most severe who have a history of violating. And when we look at the data on individuals who offend in these categories and have multiple violations of protection orders, the lethality index increases with each offense. And so that's why, at least my office and the victims that we work with are very interested in this. And it resolves that very cumbersome tolling issue, which you do see in these repeat offenders. And we were running into the issue with the tolling of, when anytime they were incarcerated or detained, that protection order would toll, and it became quite onerous on the victims and the court to try to navigate, okay, well, how much time do we add to the end of this order? And so this was to try to resolve these offenders who repeatedly violate. I hope that answered your question.
It did, thank you. Anything further? Senator Schuler.
Thank you, Mr. Chairman. I just had one question. On page 11, when I was reading through the bill, it talks a little bit about when they file an action for divorce, it doesn't supersede the order of protection, but does it affect it in any way at all? Or does it not have any effect?
Ms. Chambers.
Chairman Washit, Senator Schuler, My understanding is, we do have judges in the room. Where are you looking at specifically?
It's at the top of page 13. It just says it doesn't supersede.
Right,
So,
so I
but-
think the divorce and any custody orders would trump a protection order. I think those are scenarios when we would see, for the victim's protection, where we would maybe ask for safe exchange locations and whatnot. I think, because we understand that the right to be a parent is a fundamental right, and so the respondent, maybe even defendant, still has rights to his child, and I believe that that's saying that trumps, and Alyssa's nodding, so
Butler?
I feel like I'm on the right track.
Mr. Chairman, Senator Schuler, the way that this reads is, you will have instances where a protection order will be requested at the circuit court level, and there is no divorce action, but they have kids, or, they're not married, but they have kids. And so the protection order statutes give the circuit court the ability, the authority to issue like custody orders for the kids in the interim. And so when it goes to district court and they go through the full-fledged process, generally that custody order that's entered in the circuit court becomes moot, but it doesn't mean that the protection order is done away with. So that's the intent behind this language.
Thank you.
So this is a may for the judge on the permanent protection order. So in the event a judge opts not to issue a permanent protection order, are we still tolling? Or how does it work if the judge opts not to issue a permanent protection order? Ms. Butler?
Mr. Chairman, the way the bill reads now, that tolling provision is removed. So if this bill becomes law, then the tolling provision, regardless of whether it's a permanent protection order or one that's more temporary, that would not be available. At least that's my understanding, and I'm looking at Mr. Fuller to confirm.
Getting the head nod. That's it. Further questions? Representative Oakley.
Thank you, Mr. Chairman. And if I ask this question, 'cause it might be not the time to talk about it, so just say that if that's your answer. But, so at the last meeting, didn't we discuss a protection order based on violent felony convictions? And I thought we were talking about a bill draft for that. Is this instead, or what's your recollection on that? And maybe Mr. Fuller, maybe the wrong time, I don't know.
Chairman Washit. Representative Oakley. That was part of the discussion. I believe my testimony at that time was that if that is something, that is a policy decision for the body, and if that's something you wanted to do, I wanted to point out that that would require a new statute separate from what we currently have. And I don't think that that's that at this point is not contemplated under the draft that we have in front of us.
Okay, see no more questions. Thank you all for your testimony this morning. Anyone else in the room wishing to testify on Bill Draft 0283? Chief Thompson, welcome.
Good morning, Mr. Chairman. Listening to the testimony this morning, reading through this.
Go ahead and
couple things.
introduce yourself for the
Oh, sorry.
record, please. Yeah.
I was here enough yesterday, I forgot to do that. Chief Thompson, Evansville, Wyoming, here in Natrona County. Couple things. On page 10, it talks about statewide APLA, across the state essentially, and concerns to stalking. With these magnificent little computers we carry around in our pockets anymore, we're routinely running into people stalking their people from outside of the state, and routinely. So I do support this bill immensely. I've got a couple examples as to why we may want to look at beyond just statewide with this. One, we have a lot of transient workers between the oil and gas, wind, solar projects come in. Yesterday while I was here, I had testimony in Douglas for impact funds with a solar farm. So we keep seeing that stuff, and these workers go in and out of the state, quite a bit. A couple of quick examples. We have a lady in my jurisdiction who is selling her house. She was only married for about 1.5 years to her former husband. Older lady. He got to drinking, got quite violent. I spent about 3 months back and forth with her, and she is so petrified of this individual that she's selling her house, having to move because she's afraid that he's going to come find her, even though he's now left the state. He's in North Carolina, and he's threatening to come back here. I won't get into the details of the comments that he's been sending her, and we've sent, I don't know, probably about 12 affidavits up to the district attorney's office, in violation of the temporary one. And, reading through and looking and listening to testimony, the victims are probably the people best knowing whether they need a permanent protection order. There was the question about whether they need to be convicted, of violence. So I just want to put that out that we may want to look beyond just the statewide, and with other states having the permanent protection order in place, we may want to consider also like a reciprocity type language. So if somebody moves here from another state, that would also continue within our state. Obviously, the courts are pretty busy. Here in Natrona County, they're quite busy in the bigger populations, and it may help free up some time within the court system if we had that reciprocity in some aspects. I stand for question.
Questions for the chief? Thank you. Ms. Chambers, I'm looking back there. You want to come back up to the microphone and maybe address this interstate aspects of protection orders?
Thank you. Kara Chambers, Division of Victim Services. So in every state, we have the concept of full faith and credit. So a Wyoming order can be enforced anywhere and vice versa, including on tribal here in Wyoming on the Wind River if we have a tribal protection order. So that concept is already well established, and I don't believe we can change the language because we don't get to write laws for other states. But that concept is already well established, again, in full faith and credit.
So in a situation like the chief was describing where an offender has moved subject to a protection order in Wyoming, but continues to perhaps violate that protection order from afar,
Right.
that can be, if he ever comes back to Wyoming, that could be prosecuted in Wyoming?
Chairman,
Or
yes.
could we issue a warrant perhaps and have him
There's a,
cited?
Chairman, I believe there's a couple options. You have a prosecutor on your bench there who might be able to speak to that. But yes, my understanding is yes. Now, I don't know how many courts or sheriff's departments will go pursue an out-of-state on presumably a misdemeanor violation. But I believe there are scenarios where, say it's a stalking, we do see a lot of that electronically. I do think there are mechanisms for the victim to try to enforce that. And it might require the victim to get in contact with the state that the offender is residing in to have them enforce, again, under that concept of full faith and credit, the protection order that they have in Wyoming.
So reciprocity language specific to this bill is not necessarily needed?
Chairman, I don't believe it is.
Representative Oakley, you want to chime into this discussion?
Thank you, Mr. Chairman. I agree. I mean, the concept of the full faith and credit, I just pulled up a case I was looking at that somewhat seemed to muddy that had to do with personal jurisdiction, which becomes difficult. But regardless, I think she hit the point, which is if any sort of language, we can do whatever we want, making language specific to Wyoming, but we can't do something that would bind other states. So, but the full faith and credit as far as respecting and recognizing a protection order from any jurisdiction is is the law.
Thank you very much. Anyone else in the room wishing to testify on this bill? Anybody on Zoom? Anybody on Zoom? With that, I'm going to close public comment on 0283. Committee, what's your preference? Moved by Senator Cooper, second by Representative Harrelson. Any amendments? Any discussion? Discussion, Representative Provenza.
Thank you, Mr. Chairman. I would like to allow LSO to draft or put in this bill language for upon good cause, so the staff comment on page 4. I'd like to have LSO put that in here so that people can potentially have their permanent protection orders rescinded upon good cause.
Second to the motion, second by Representative Harrelson. Discussion on the amendment? Seeing none, Mr. Fuller, we're clear that we're just going to implement the staff comment there. Committee, all in favor of the amendment, say aye. Aye. Those opposed, no. That amendment has carried. Further amendments or discussion? Hearing none. Roll call on 283.
Mr. Chairman, this is a roll call vote for 25 LSO 283, permanent protection orders as amended. Senator Case? Senator Cooper? Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Crago? Representative Harrelson? Representative Jennings? Representative Nemec? Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Rodriguez-Williams?
Aye.
Co-Chairman Landon?
He left an aye.
Chairman Washit?
Aye.
Mr. Chairman, we have 14 ayes.
Thank you very much. That takes us to our next item, our 9:45 item. Nice to be ahead of the game instead of behind as we were most of the day yesterday.
Different leadership, Mr. Chairman. The other one's out of the room.
Adoption and foster care issues. Director Schmidt, I see her today. Why don't we stand at ease for just a few minutes, maybe take a 10-minute break. We're ahead of the game to the point where some of our witnesses may not be here yet. So we'll take about a 10-minute break. Welcome back. Representative Oakley. Representative Oakley?
Thank you, Mr. Chairman. I would like to make a motion to reconsider the bill that we, what is it? 25 LSO 283?
Is there a second on the motion? Second by Senator Schuler. Committee, or how about a quick discussion as to your purpose?
Thank you, Mr. Chairman. So we had some discussion at the last meeting about this, that fits in with this concept in this bill. So before we leave it, I thought it would be a good time to have this discussion and see if we want to go this direction, to include in a permanent protection order, sort of, I don't know if you want to call it automatic, but a protection order based on the fact that the defendant or respondent has violent felony conviction. So it would be for the victim when they are the convicted, the known victim of a violent felon, and they're the victim on it. And so I've had some discussions with Mr. Fuller, the wonderful Mr. Fuller, and he thinks he's got a good place that we could add this in. And so rather than doing it at a separate time or coming back a separate year, I mean, we're creating a permanent protection order. Let's have this discussion if this is a subsection that we want to include. So if that's the thought behind
That's
it,
the
Mr.
purpose.
Chairman.
All right, further discussion on the motion to reconsider. Same bill we just finished, 283.
You're just wanting an amendment to the one we just.
Right. So, committee, all in favor of reconsideration of 283, say aye. Aye. Those opposed, no.
No.
I think we have a majority. All right. Representative Oakley.
Mr. Chairman, so I guess two things. If obviously, I think Mr. Fuller's ready to go. And then if we can, I request testimony, but I would kind of like to hear from Judge Christensen if he's willing to come up, answer questions, and tell us what he thinks this might look like.
Judge Christensen, please. Ms. Chambers.
Mr. Chairman, Brian Christensen, Circuit Court Judge, Natrona County.
So refresh our memories, some of the discussion from our previous meeting about permanent protection orders automatically being triggered by a violent felony conviction.
This was 2 meetings ago from a question from Representative Provenza, Mr. Chairman, about, I just threw out there are permanent protection orders out there when we were looking at the tolling statute and the problems with that. And then the LSO did a study of other states, and one of the things not included in there, though, was victims of violent felonies, which is already defined. Would that be appropriate for a permanent protection order? So that's where that discussion went. So when you're a victim of a conviction of a violent felony, would you be entitled then to a permanent protection order? That's the issue.
Okay. Questions for the judge? That answer your question, Representative Oakley?
Yes, thank you, Mr. Chairman. And then if you guys will stay up there, can we have Mr. Fuller run through what he has as proposed language?
Mr. Fuller?
Yep, so Mr. Chairman, this is on the fly. It would go page 2 after line 19. It would be a new subsection B and then renumbering accordingly. And it would read something like this: upon conviction, the district court shall enter a permanent order of protection under this section in favor of the victim against a person convicted of a violent felony as defined by WS 61104A12.
Okay, everybody clear on what that entails? Representative Harrelson?
Thank you, Mr. Chairman. Just a real quick, was that shall or may?
Yeah, Mr. Chairman, Representative Harrelson, that's a shall.
Okay.
Yep.
Okay. Representative Provenza.
Thank you, Mr. Chairman. I guess for you, Judge, I mean, can victims easily obtain this anyway?
Mr. Chairman, Representative Provenza, not a permanent protection order. That's the problem with the tolling. When a conviction occurs, a victim could run right in and it's res judicata. You get your 3-year protection order, then you would have to get a good cause extension for 3 years, 3 years, 3 years.
I guess in clarity, anyway in this bill, so the way that we had passed it 10 minutes ago, there would be a permanent protection order, just didn't have the felony issue in it. And so my question is, under it, with the bill as it's written, can't a victim easily get the permanent protection order with this bill in place before the reconsideration?
Mr. Chairman, Representative Provenza, it'd only go to convictions for strangulation, third offense, domestic battery, sexual assault. This would expand it to victims of attempted homicide, maybe families of homicide victims, any violent felony that is listed, so it would expand those areas.
Representative Jennings.
Thank you, Mr. Chairman. Judge, run through the hypothetical here. Let's take families. One family member kills another family member. The protective order, the victim is everyone else in the family. Theoretically, because they lost a family member. It looks to me like that this being put in place could create some family issues, as if there weren't already some.
Mr. Chairman,
So how would that play out?
Representative Jennings, that would be a decision for the committee to make. How far you wanted to go with what a victim is defined.
Representative Provenza.
Mr. Chairman, thank you. What if we, instead of the proposed language of shall, we said may, and the courts could provide the permanent protection order in these instances? Would that be problematic?
Judge.
And Mr. Chairman, Representative Provenza, it already does say may in 713-513, and this is the proposed bill. Yeah, you could mirror it, but that would still be a decision for the committee, may or shall.
Representative Jennings.
Thank you, Mr. Chairman. So, Judge, having sat on the bench and seen this type of circumstance occur on occasion, I'm sure, or at least been closer to it than most of us, does it give you heartburn to force that, to put a shall in there and not give the discretion to the court? Because it gives me heartburn to say shall. I can imagine a circumstance where there was abuse in the family and one family member in their mind corrects the situation, and now there being a protective order now estranges family members at a time where they at most might need family glue. Does that make sense? Could you speak to that? Just a little?
Mr. Chairman, Representative Jennings, I think it's in the bill as proposed that the victim can withdraw that request.
Follow-up?
Yeah, thank you, Mr. Chairman. So, but a lot of these things happen, say an older sibling that has some understanding and steps in, and the younger sibling doesn't have that. You have juveniles and things of that nature that, and they're already in a very, very upside-down, confused world. It's unlikely that they would have a full grasp that they could go petition the court to remove a permanent order. So do you have any heartburn there?
Judge?
Mr. Chairman, Representative Jennings, yeah, I think we could think of all kinds of hypotheticals on those. I think those petitions can be filed by friends of the victims, other family members to withdraw the permanent protection order. But, you know, and it all gets back to how you define the victim to begin with as well. And if, and also Representative Jennings, if they're already a convicted felon, there's probably a no contact in there already.
So I guess my question is, if this takes place upon conviction rather than upon sentencing, there's not a PSI done, does the judge have all the information he needs to implement the parameters of that protection order at that point?
Yeah, Mr. Chairman, that would be an advisement, I believe, that if upon conviction, the victim would be entitled to a permanent protection order, and then the victim could withdraw that if they wish. So I'm understanding this, but.
Okay. Representative Oakland?
Thank you, Mr. Chairman. And correct me if I'm wrong, I'm just trying to answer that question. I think in the law used, upon conviction would mean after sentencing. Right. I mean, it would be after JNS and after they're sentenced. I don't think this contemplates this the minute they plead guilty and prior to sentencing. That's not my understanding of using the phrase upon conviction.
Further questions for Ms. Chambers or the judge? Seeing none, thank you. Any further testimony on this discussion about violent felony protection orders in addition to the other? Seeing none. Senator Schuler.
Thank you, Mr. Chairman. Could you read that again, the amendment? I didn't quite get all of it, and
Yeah, so, Mr. Chairman, page 2 after line 19, and this will also go on page 5 after line 12 for the Domestic Violence Act. But it would read, upon conviction, the district court shall enter a permanent order of protection under this section in favor of a victim against a person convicted of a violent felony as defined by WS 61104A12.
thank you.
Representative Harrelson.
Thank you, Mr. Chairman. I think there's a point where we almost handcuff the courts if we're not careful there. I mean, a may in there is, I think, way better than a shall. If they look at the situation and go, you know, this needs to be in place. They have the freedom and the ability to do that. And at the same time, they're like, you know, the circumstances in this situation, I don't feel like that's the option. And we're not handcuffed to make that. I mean, could we put that as a may instead of a shall? I just have heartburn over sticking it into this place where we make our judges have no other options.
So we have a motion on the table to introduce this language with the shall. We can vote that down and then enter a new motion at that point if you wish. If
Or
that's
could
what
we
the
do a
committee
friendly
desires.
amendment?
Okay. Further discussion on the proposed amendment, which is shall? Representative Jennings?
Thank you, Mr. Chairman. So I'm in favor of this bill, but I'm not in favor of taking that latitude away from that judge. I can easily see circumstances that can occur that the shall is going to impose a chain of events that in some circumstances are not going to be the desired outcome. And so I can't support the shall. I'm certainly in favor of the may. And make it available. It's a tool. There's a reason there's different branches of government, and we trust them to understand the nuances of the case. That's why they're judges. That's why we pay them the big bucks. And so I'm not in favor of hamstringing them with a shall to have to come back at a later date and try and sort out what ramifications the shall may have.
Representative Chester.
I just trust the judges.
Thank you, Mr. Chairman. And I also am opposed to this amendment. I also don't think it's necessary to change it to a may, because I think Romanet 1 on page 2, line 14 covers it. The court shall consider the respondent's history of violence, severity of the offense at issue. So I think if that gives the court authority right there to consider those things. And I agree that we don't want to hamstring the courts. I think, one-size-fits-all solutions generally I don't care for. And the shall that's been proposed here is a one-size-fits-all that could create problems in unforeseen circumstances, and I'm opposed to it.
I think the distinction here is that without the amendment, we don't include the other violent felonies. We're limited to the stalking, domestic violence language in paragraph A. So this would allow, whether we pass it with shall or may, expand that to other violent felonies. I think is an important distinction there. Representative Crago.
Mr. Chairman, I guess I'd like to ask Brian about that, because I'm not, the way I read it, you can apply for it for any crime. The victim of any crime can apply for the protection order. So I guess let's ask Brian on that, because I think there's some confusion on that. And that was one of the questions I had when the judge was testifying about that. I just don't read it that way. I'd like some clarification.
Brian?
So, Mr. Chairman, victims not defined in this article. I think it's true that under the other sections in this article, if you look at page 3, those standards, they are specifically limited to stalking, sexual assault, or of serious physical adverse consequences. This section, Mr. Chairman, the only reference to stalking or sexual assault is page 2, lines 8 through 12. It says the permanent order of protection shall order the respondent to refrain from any contact or further acts of stalking or sexual assault. The standard, though, Mr. Chairman, for the permanent protection order does not specifically reference sexual assault or stalking. You're considering history of violence, severity of offense, and evidence presented, and you determine that to avoid further injury or harm to the victim, which is undefined. The victim needs permanent protection. So that would be my observation, Mr. Chairman. This section, there is the one mention of it in what the permanent protection order must order. The standard, though, as compared to the other language, does not explicitly reference sexual assault or stalking.
Representative Crago, does that answer your question? All right, so we have before us, committee, a motion to include the shall language that Mr. Fuller provided to after line 19 on page 2. All in favor of that amendment, say aye.
Aye.
All opposed, no? No. That fails. Further amendments. Representative Harrelson.
Thank you, Mr. Chairman. I would like to just kind of reintroduce Mr. Fuller's amendment with a may instead of a shall, and I believe it kind of stands, already been discussed.
And a second by Representative Provenza. Discussion on the amendment? Seeing no question being called, all in favor of the amendment with the may language, say aye.
Aye.
Opposed, no. That motion carries. Further amendments while we have this bill before us. Yeah. Seeing no further amendments or discussion, have a roll call on the now amended 283.
Mr. Chairman, this is a roll call vote for the reconsideration of 25 LSO 283, permanent protection orders as amended. Senator Case? Senator Cooper? Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Crago? Representative Haroldson? Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza?
Aye.
Representative Rodriguez-Williams?
Aye.
Co-Chairman Landon? Chairman Washit? 14 ayes.
So that takes us now to adoption of foster care issues. Director Schmidt. You're up. Okay, so we have a bill draft before us, 25 LSO 0004 version .8. Is that correct?
So, Mr. Chairman, I think we're maybe jumping a topic. So topic number 11 on the agenda, Mr. Chairman.
My bad. Yep.
I prepared a memorandum for the committee. It's 11-01 in the meeting materials. That was just in response to questions that were raised at the September meeting. The memo just provides the general lay of the land concerning the parents' rights, the fundamental right to the care, custody, and control of children. Then going into the laws that concern termination and requirements for reunification efforts under Wyoming law. And then, Mr. Chairman, I included information on other states' laws concerning the termination of parental rights, those grounds for termination, and the situations or scenarios under other states' law where reunification is not required in specific instances. Mr. Chairman, happy to go through it in more detail. Also happy just to stand and answer questions on the memo.
Questions for Mr. Fuller about the memo? Seeing none. Director, have you seen that memo? Any comments?
Good morning, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the director of the Wyoming Department of Family Services. The only comment I would have to offer is that you see a lot of similarities from jurisdiction to jurisdiction, and that's in large part because many of the laws that we have are based on federal law as well. So just to point out why you see such consistency from state to state.
Mr. Co-Chairman.
Thank you, Mr. Chairman. So, Director, by the way, Mr. Fuller, I thought the memo was outstanding. It was really informative. Did you, Director, pick up on anything Kansas or Oregon or Utah, or did you see anything in there that, boy, I sure wish Wyoming were doing this or allowing us to do it? Did you pick up on anything in particular?
Director?
Mr. Chairman, Mr. Co-Chairman, I can't remember which state it was, but there was one reference to an expanded notion of when there was some sort of sexual assault on a child in the family, not just the child in question, but the child in the family, some consideration given to that about leading to termination of parental rights. That would be something that maybe to consider. But again, they're also slightly similar, and I'm not real anxious to speak out about it, mostly because the differences between the different types of legal definitions of all of those things get very confusing to me.
So, Director, we heard, a lot of very emotional testimony from parents, foster parents who've been trying to adopt. And so my question for you is the department confident that the process and the rules that we have in place today are as good as they can be? Or is there some recognition that maybe there's room for improvement? And if there is room for improvement, what's the plan for the department to seek those improvements?
Mr. Chairman, of course, coming from the executive branch, I'm always going to think about the executive branch options first before thinking about statutory changes. I think where we could invest some time, and I think we'll be in a better position to invest some time into looking at how quickly a case, once a permanency decision has been made by the judge for adoption, to be able to move to termination of parental rights and then to move forward with the adoption. I do think that is a place that internally we could think about. One of the reasons why I think that might be a low-hanging fruit is because we are moving into our new case management system, which gives us capacity to track a little bit better and therefore flagging some of those cases maybe that are lagging easier. And also the information that's captured in that new case management system is eliminating the need for a lot of our paper files. So pulling all of that together oftentimes is very time consuming for a worker, and then getting that to the Attorney General's office and then going through that is all time. And hopefully we'll see some efficiencies on that end. In regard to the specific question about a foster family that is wanting to adopt, I think where we could do a better job, and this speaks to the training that we do when we are engaging with prospective foster parents. The testimony that we had, that we provided in the last couple of months really does speak to our first and foremost priority is to try to reunify. And while we appreciate the numerous foster parents we engage with, I also think that that's time for sometimes what is a very difficult conversation with people who are wanting to engage in the system in order to potentially be a foster adoptive parent. So it's hard to have those conversations and remember those conversations when you're in the middle of a very heartbreaking event, like a family or a child going back to their biological family. But I do think our training process, we can make sure that we're doing better to reiterate that along the way so that everyone is coming into this agreement eyes wide open. And also along the way, having the conversations with foster parents when we know maybe that they're hoping for a little bit more and providing them with the support they need at that time as well. So a statutory fix, I don't necessarily see one. A training fix, I do believe that is a potential. And we are starting to implement a new training curriculum for foster parents, prospective foster parents, where I think that conversation will be easier to have.
Thank you. Yeah, I just keep coming back to, I think it's the 15 months, the last 22, and how often we really don't get resolution within that timeframe, right? And I think that contributes just much of the issue that we heard from these families, and the very genuine concern to do what's in the best interest of the child, and how we balance that with the mission of reunification when feasible, and at what point we make that determination that we're not going down that road. So I think there's still room for improvement, maybe statutorily. I don't know if I'm completely sure that we're out of that discussion as a legislative body, but we want to get this right. And I think the message I heard from the committee was we'd rather slow down, make sure we do this right, as opposed to just responding to the emotional appeals from the fosters that we heard. So I do appreciate that the department is continuing to reevaluate and seek remedies within the executive branch. I see Judge Buchanan in the back. He testified on this issue last time. Any interest in coming to the table? Feel free to come up if you wish, Judge. Otherwise, no pressure. Very good. Representative Rodriguez West.
Thank you, Mr. Chairman. Director Schmidt, a couple meetings ago, we talked a little bit about the Kinship Connections Program and the success of that. And I'm just curious, it looks like there's some partnerships and grant funding there. What does that look like moving forward? When does it expire? Will you be reapplying, that sort of thing?
Director.
Mr. Chairman, Representative Rodriguez-Williams, I don't have off the top of my head the expiration of those dollars. Typically, it happens on a federal fiscal year, so the end of September. I can tell you from an agency standpoint, that is a priority program for us. And so regardless of, the federal funding, we will continue to look for ways to support it with state general fund if we have that available. But it is a great representation of what community and families can do without having to have the agency get involved. And we're very much interested in supporting more of those types of initiatives. So I can't give you a definitive answer, and I can certainly we can send that to you. But just know that our commitment is there.
Further questions for the director? Seeing none. Thank you very much. Any closing comments?
No, Mr. Chairman, thank you.
Any public comment on this adoption foster care issue? Any public comment? Anybody online? You want to close public comment? Committee, is there any desire for action at this point? Seeing none, Mr. Co-Chairman.
Mr. Chairman, thank you. So, Mr. Fuller, there was a reference to maybe a stricter kind of language that the director may have run across in your work. Did any light bulb go on for you, having done the homework on each of these other states that you outlined for us? Was there some language that stood out to you that we have not adopted at some point in our past?
Mr. Fuller.
Yeah, Mr. Chairman, Chairman Landon, I'm hesitant to say, a light bulb went off. I think that's, probably questions of policy. Here are the observations I would offer, though. The exceptions in other states, similar to Wyoming, concern, so when I say exceptions, I mean exceptions to the requirement for the Department of Family Services or that state's analog to engage in reasonable reunification efforts. The exceptions to that reunification requirement, similar to Wyoming, generally concern offenses that are committed against the child for who the rights would be terminated or other parent. Some states, though, reference actions or crimes against a child or any child. Oregon, for example, uses that specific reference. Other exceptions concern the neglect, abuse, or torture of a child. If parental rights are terminated to another child involuntarily, that in some states is also a situation where in those states reasonable reunification efforts would not be required. And then another area is mental health issues of the parent. If a parent is found to be so mentally ill or incapacitated that the parent's unable to care for the basic needs of the child.
Mr. Co-Chairman.
Thank you, Mr. Fuller. I appreciate it.
Senator Schuler.
Thank you, Mr. Chairman. I actually, after our last meeting, had a bill drafted by Mr. Fuller, which added another potential. I think there's 9 grounds in Wyoming statute for how the permanent or the termination of parental rights could be done. And I just felt like that the testimony we had from a grandparent was really compelling. I didn't want to put Director Schmidt on notice that I hadn't had a chance to talk to her personally, but I wouldn't mind hearing if she thinks this might be something that might fly. And here's what it is. It says the child has been appointed a guardian who is a relative of the child. The child has been under the guardian's care for more than 24 months, and the parent is unfit to have the custody and control of the child. So if you'd like to, throw out your thoughts on that, I'd love to hear them. Is that okay?
Director.
Thank you, Mr. Chairman. Senator Schuler, this is actually an interesting conversation for the agency because the issue that you're speaking to doesn't involve the Department of Family Service and state custody issues. So going back to that very original testimony we had last spring, there were two people that were sitting before you, both with concerns about the termination of parental rights statute. However, one of those testimonies, one of those witnesses actually had no involvement with the agency. It was a private guardianship in a private situation that DFS nor DFS or our Title 14 statutes had to play with. So to your question directly, that is a policy call. And I do think that it's something worth discussing. I know that it causes a lot of consternation and a lot of heartbreak for those guardians or grandparents who are trying to take care of those children, and they themselves also don't have permanency because the way that their children or whoever can come in and out. And the difference is they don't have the benefit of a state agency helping along that way, helping to case manage, helping to connect to resources. So it truly is a policy call, but I appreciate the opportunity to speak to it.
Further questions? Follow-up?
Chairman, I just knew that she was going to say that. It was a policy decision, but I just wanted to hear it anyway. Thank you. Thank you for your thoughts.
Okay, let's see, no more further action from the committee. We move on now to our 10:30 a.m. Mental Health and Vulnerable Adult Task Force. Representative Larson, Director Schmidt. And now we get to that bill draft I erroneously referenced a few moments ago. So, Mr. Fuller, you want to walk us through that bill draft?
I can, Mr. Chairman. 25 LSO 0004 should have draft 0.8. This is 12-01 in the online meeting materials. This is a bill draft of the Mental Health and Vulnerable Adult Task Force developed and forwarded to this committee for consideration. In September, the committee received an overview of this bill draft and directed that it be forwarded to this meeting for consideration as a committee bill. This bill draft would authorize the sharing of certain data under specified circumstances and creates exceptions for the sharing of that confidential information for purposes of evaluating the effectiveness and impact of programs and services that the Department of Family Services offers. So on page, and Mr. Chairman, just a note, this bill draft, the only thing that has changed from the last meeting is on page 1. That sponsor line is the only change that was made to this draft. So page 2, lines 9 to 15 would provide that notwithstanding any of the confidentiality requirements of a number of statutes, which I'll note in a moment, the Director of the Department of Family Services is required to review the effectiveness and impact of programs and services that include sharing data to the extent permitted by federal law for purposes of referrals, the provision of services, and participation in bona fide research. Mr. Chairman, the statutes that are referenced on page 2, lines 10 and 11 concern the Child Protection Act, the Juvenile Justice Act, statutes concerning juvenile probation, the Children in Need of Supervision Act, the Juvenile Justice Information System, Adult Protective Services, and Public Assistance and Social Services. Then, Mr. Chairman, the remainder of the bill draft are conforming amendments to just reference that new paragraph. So page 3, line 1, line 10, and line 21. Again, on page 4, line 10 and line 20. Page 5, lines 20 and 21. That change would extend access to the statewide longitudinal data system under the Department of Education, extend that access to the Department of Family Services. And then, Mr. Chairman, conforming amendments again on page 6, line 6, and lines 19 and 20. Page 7, line 4 is rulemaking authority for the Department of Family Services to implement this act. Page 7, line 8 is a reporting requirement where the Department of Family Services would report to this committee on the types of data that are shared under this act and any safeguards implemented to protect that personal data. That report would be due by next October 1st. and then a split effective date with the statutory changes on July 1, 2025. The remainder of the bill draft would be effective immediately. With that, Mr. Chairman, happy to answer questions.
Questions for Mr. Fuller? Representative Craigo.
Thank you, Mr. Chairman. So, Mr. Fuller, all of the section numbers or statute numbers after the lists on page 2, lines 9 through 15, all of them are listed except Title 21. So 21-18-202 is not in that exhaustive list. I was just curious why.
And Mr. Chairman, Representative Craigo, that is a different change. That's not a conforming amendment. That would extend, and the director may be able to better speak to this, but that would extend that longitudinal education data system, extends access to the Department of Family Services. So other than that change, the remainder of the changes just reference that new paragraph that are on page 2.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Fuller, since this is a new duty for DFS, is there a fiscal note
Roland.
expected?
Yep, Mr. Chairman, Representative Rodriguez-Williams, I certainly can't speak to any fiscal note that hasn't been prepared and wouldn't be prepared unless the committee were to forward this for sponsorship. But Mr. Chairman, perhaps the department can discuss any potential fiscal impact that they may foresee.
Further questions, Mr. Fuller? Thank you very much. Chairman Larson, or Vice Chairman Larson. Committee.
Thank you, Mr. Chairman and members of the committee. We talked about this bill a couple of months ago and bringing this forward, and it just would remind the committee, one of the reasons that we felt that this bill was really important is the work that we've done over the last couple of years, actually last 4 years, as we keep finding these unintentional roadblocks that have been put in place inside government that then has created silos and has prevented agencies from being able to talk to each other, having systems created that then can't talk to each other, that then when we have a situation arise and they're not, one agency assumes that the other agencies know what's going on, but they don't. And so we've been trying to knock down some of those silos and make sure that we have communication between agencies on all of these mental health issues, to where that we coordinate services, whether it be adults or adolescents or in the K-12 model. And I'm sure that Director Schmidt will get to that, but a good example is that point that Representative Craigo brought up in Title 21. SLEDS, Department of Family Services, wasn't included in SLEDS, but yet this last session, we required Department of Family Services to fund a grant to a consultant to do the e-kids data finding that then will be provided to SLEDS, but they can't coordinate that. So this is an effort to try and make sure that we have that the information is fluid across agencies as warranted.
Representative, do you see if this bill draft were to become law, is this going to facilitate potentially cost savings in terms of coordination and removal of duplication? Or is it a separate issue of just looking at longitudinal data?
A bird in my ears whispered potentially, but I think that's fair because we've gone through, you'll recall over the last 4 years, some real significant system upgrades that now are able to communicate with additional systems. And so that would negate the need to have multiple systems to do the same work. I think more importantly, then I don't think it has potential cost savings. I don't feel that it will impose new additional costs. I'm really confident of that. But what it will do is ensure that we don't have these individuals
falling through the cracks. And that's probably where our greatest potential for savings are, is if you can divert somebody away from the county jail or Title 25 into a community mental health provider that we're funding, is a cost savings to the county and to the city. If we can get a child in the K-12 model that's been identified early of having some challenges and get them referred, then that'll be a cost savings. If we're able to take this small number of adolescents that have very high and difficult behavioral challenges that no one in the state will take, and have a place for them to go until a more permanent position is found, that saves the impact on the counties again and on local resources. So I think that's where our biggest potential of savings is at.
Senator Schuler.
Thank you, Mr. Chairman. Along that same line, because I know we send some of our students, younger folks anyway, out of state, how will this sharing of data affect that? Will it help that? Will it hinder it? I mean, with the systems, if we can, get our systems all talking together, then can we share that data across to, Utah or Colorado or whatever? Or do you have any idea on that?
Director.
Thank you, Mr. Chairman. Senator Schuler, the statutes are related to Wyoming. And so a lot of the communications then a lot of this legislation is because of the way that our current statutes are written. So it's trying to provide some flexibility to be able to share data when necessary under limited circumstances. So to the point about sharing data across the state, cross-jurisdictional, I do think that could be helpful. I don't know about a cost savings or if that would reduce the number of out-of-state placements, but where I do see it would be very beneficial to your neck of the woods is when you have families that maybe live in one state, Idaho or Utah, but yet we encounter them in our system in Wyoming, being able to go back to that state and have a conversation. Right now, the way that the statutes are written and interpreted, that is a much trickier conversation. It's a much more legal conversation at that point.
Further questions? Anything further from the three of you? Okay. As this committee's dealt with a lot of different issues over the years that I've been in Judiciary, data seems to be the one thing that we're always clamoring for, right? Better data, better information so that policymakers can make more informed decisions. And I really see this as a step in the right direction to helping us have that data to fill in the gaps of information that we're missing presently. So thank you for your hard work on the task force. Mr. Co-Chairman, anything?
Just to echo what you mentioned, Mr. Chairman, appreciate it. Representative Larson, all the work that you've done on this front. Hopefully we can take it forward. Directors play a key role. Appreciate you guys. It's our job to get it up and through now, so thank you.
All right. Anyone else in the room wishing to testify with regards to 25 LSO 0004 version 0.8? Anyone else in the room? Anyone on Zoom? Okay. I'm going to close public comment on that bill draft. Committee, what's your preference with regards to 0004? Moved by Senator Schuler, second by the co-chairman. Discussion, amendments? Sensing an urge to vote, roll call vote on 0004.
Mr. Chairman, this is a roll call vote for 25 LSO 4, Department of Family Services confidentiality amendments. Senator Case? Senator Cooper? Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Crago? Representative Haroldson?
No.
Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams?
No.
Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 11 ayes, 3 no.
Thank you very much. And now we move on to Bill Draft 0103. I'm a little cautious, Mr. Co-Chairman. We're ahead of our agenda timeframe, and I worry about public comment. People might be anticipating joining us a little later in the morning. Then I don't want to get too far out in front and then have somebody show up and say, we missed our opportunity to testify on this bill. So I'm going to take about a 10-minute break for the committee, and then we'll rejoin because we're ahead of time. Yep. All right, committee will resume where we left off, which was with 25 LSO 0103 version .12. Mr. Fuller?
Yep, and Mr. Chairman, with your indulgence, I'm going to turn this over to my good colleague, Anna Johnson, who was the drafter of this. She's appearing by Zoom from the office.
Terrific. Welcome, Anna.
Good morning, Mr. Chairman, members of the committee. I'm happy to go over 25 LSO 103 for you. So this bill draft is entitled 25 LSO 103 Treatment Court Amendments. And right now we're on version 12. And so beginning on page 2, several treatment court definitions have been amended. The definition of applicant was changed to include one or more governing bodies. And then under that, continuum of care was amended to include mental health treatment. And dual diagnosis was amended to say substance use instead of substance abuse. And then participant was changed to include persons with mental illness or dual diagnosis who have committed an offense, including those who have had law enforcement contact with or without arrest. And then program was amended to include one or more local court supervised treatment or mental health programs. Referring judge was amended to strike substance offenders and include participants. And then substance abuse assessment was changed to substance use disorder assessment. Substance abuse treatment was changed to substance use disorder treatment, and substance offender was changed to include a person arrested for, charged with, or adjudicated for a substance-related offense. And then the definitions of mental health treatment, mental illness, and substance use disorder were added. And then at the bottom of page 5, Wyoming Statute 512-105 was amended to include unmet mental health needs and mental health screenings. And then under subsection B on page 6, the goals of the programs were amended to include striving for recovery and mental wellness of participants, and to reduce the number of people with mental illness in jail, criminal court proceedings, and the state hospital. Wyoming Statute 512-106 was amended to change referring judge to referring judges. And Wyoming Statute 512-109 was amended to remove substance offender and insert participant. Subsection C, beginning on the bottom of page 8, indicates that referral and participation in a program and consent to participate shall be governed by the rules adopted by the Supreme Court and Title 14 for juvenile participants. Language regarding consent is stricken from subsection D on page 10. A new subsection E on page 9 indicates that a program may accept participants from any other jurisdiction in the state. And then 512-110B on page 10 indicates that if a participant is participating post-adjudication, they may be subject to incarceration as a sanction. A conforming amendment was made to 512-111 on page 10. And then 512-115A on page 10 was amended to strike substance abuse and insert substance use, and to show that participants may have to submit mental health history to the program team. And then all participants may have to disclose the number of children they have as well as their mental health records. Wyoming Statute 76104E on page 11 is created to show that the public defender is authorized to serve on court supervised treatment program teams and may represent participants in those programs, including sanction and expulsion proceedings. All of the amendments from the bottom of page 11 to the bottom of page 22 are conforming amendments changing the term substance abuse disorder assessment to substance use disorder assessment. And then section 2 indicates that Wyoming Statute 512-107C2 and 512-109A and B little I to little IV are repealed, and that stricken language is in a staff comment starting on page 23. Section 3 is a rulemaking section. It also indicates that the Supreme Court should make any necessary requests to support court supervised treatment programs in its biennial budget request. And then section 4 contains an immediate effective date, and I would stand for any questions.
Thank you for that. Committee, any questions? Seeing none. Representative Larson.
Thank you, Mr. Chairman. I think when we presented this to you in September, we were on version 11, and we came back in and clarified a few things per some questions that you all had for us, and amended version 12 a couple of times, working with the treatment courts and the individuals who provide it. One of the conversations that I think is important for the committee to recall is that prior to this last session, treatment courts were under the direction of the Department of Health. So we've moved them into the judicial side. So in doing that, there was, and they looked at that, there was some, they identified some things there that they thought needed conforming. Then we brought in this diversion court pilot in that we're doing, and we need to make sure that we have language that allows for that system to be in place. And so this is conforming all of that treatment court stuff. One of the questions we had last time was, you know, what's with this substance use disorder? Why don't we just stay with substance abuse? And we sent out a little summary of why that changes, and it's because it really has expanded beyond just the judicial use of it. I think one of the most interesting things for me when I was having this conversation with one of the providers was they says, well, when you talk about substance abuse, that works really pretty well if it's a prescription drug, because there's an identified dosage, and if they're using or doing that, they're abusing it. But if it's heroin, what's the dosage for heroin? When is it that you're abusing what heroin's intended for? It's an illegal drug that they're using, and depending on, there really is no abuse. And so that the language that we use there, that we now have in statute that this refers to, is that a use disorder means that the use is without compelling medical reason of any substance which results in a psychological or physiological dependency as a function to continued in such a manner as to produce mental, emotional, or physical impairment and cause socially dysfunctional behavior. And so without medical reason, they're using it to do any of those things, that's a mental use disorder. And so that's the definition that we use, and we shared that rationale with you, and happy to answer any questions regarding that, Mr. Chairman.
Committee, any questions? Mr. Co-Chairman?
Mr. Chairman, thank you. This is probably, very elementary, but Representative, at the bottom of page 10, we strike the need to potentially provide substances of choice, and I'm a novice in this area, so I'm not sure, but apparently we feel like history and medical records both will be adequate enough to know what all this patient has been up to. I'm just curious why we would not want to know or need to know all or part of the substances that they might be involved with. Will the medical records catch that?
Representative?
Thank you, Mr. Chairman. That's caught in understanding in their use disorder. So if we go back to that definition I talked about, it's the use of any substance. And so identify, that would be that substance of choice, my drug of choice, would then be captured in that history of the disorder.
Representative Rodriguez-Williams?
Thank you, Mr. Chairman. Representative Larson, on page 24, I'm trying to wrap my head around lines 7 and 8. On page 24, it says a substance offender who is a defendant in a criminal action or a respondent in a juvenile court action may be referred for participation in a program if. So it's kind of vague when we're talking about criminal action, and being a defendant in a criminal action. I'm just curious, I mean, what type of crimes are we talking about here? I don't see any real sideboards to this. It's
So,
pretty vague.
Representative?
thank you, Mr. Chairman. And so Representative Rodriguez-Williams, that's existing language, of course, in there, and then they're showing in Romanets 1, 2, 3, and 4 what we're now removing out of existing statute, right? And so then help me understand, because a substance offender who is a defendant in a criminal action or respondent in juvenile court action may be referred for participation if, and then
Mr. Chairman.
Ms. Fuller?
Yeah, if I may, Representative Rodriguez-Williams, on page 7 of the bill draft, that language in subsection B is actually stricken as well that you referred to. So that language is stricken, and then the paragraphs that follow that intro language would be repealed.
That
Thank you,
answer your
Mr.
question? Any concerns? Go ahead. Follow up?
Mr. Chairman, if I could just add to that, the other thing that limits that language is substance offender is defined in the statute. And so it wouldn't be any criminal conviction, right? So you would have to be a substance offender who had a criminal conviction. And so the substance offender is what further limits that referral. And I'm not sure if that helps, but it does, it's not just any criminal conviction. It is limited by the substance offender language there.
Senator Schuler.
Thank you, Mr. Chairman. First of all, thank you, Representative Larson, for that was one of the questions I had, though, in terms of why we changed from substance abuse to substance use. And no, I appreciate that background. But my question is on the public defenders. I think it's great that we're going to authorize them to serve on these programs. Have we reached out to many of them to ask them how they feel about the whole thing? And I mean, I think it's a good move, but just wondered.
Mr. Chairman, Senator Schuler, I don't think I introduced myself again. I'm sorry. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. We did actually talk with the public defender. This was at their request. So the big issue that they had is they had a concern that their malpractice insurance did not cover them unless it was they were given authority to do this in the statute. And so they wanted to have their malpractice insurance cover. And so the request was that they specifically be included in the statute to allow that.
Thank you.
Representative, on page 9, line 6, says, when we talk about accepting participants from other jurisdictions, an issue of some sensitivity in this community is this a round trip? So we accept a participant from one part of the state, they come to another part of the state to participate in the program. Is there a plan to get them home again?
Mr. Chairman, that's a great question, and I think that's the importance of the may language. And so then the authorizing committee working with the other jurisdiction would have the ability to put that in place, that, okay, yeah, you can come to this treatment court, but it's not our jurisdiction's burden to get them back home. And so I think that falls, we don't spell that out, but it's, rather than having a shall there, it's a may, depending on if they can come to an agreement.
Representative Rodriguez-Williams, did you have another question?
Thank you, Mr. Chairman. Representative Larson, again, on page 24, under section 3, it states that line 30 and 31, it states that it is the intent of the legislature that the Supreme Court make any necessary requests to support court supervised treatment programs. Just curious, like, what does that look like? I mean, who are you hoping to gain support from? What type of requests are we looking at?
Representative?
It would be budgetary. This is referring to, so treatment courts are in the Supreme Court now, and it would be within their budget, and that they find necessary, it's that those budget requests would come through the Supreme Court and not another agency.
Any other questions from the committee? Seeing none, thank you both. Any closing comments from either of you?
Mr. Chairman, I have one additional comment and potential amendment. And so one of the things that we have very recently run into, so we did not have time to run this through the Mental Health and Vulnerable Adult Task Force, was the definition of participating judge. That's not currently in the bill draft. So it is in state statute now. It is 512-104A Romanet 7. What it says right now is participating judge means the district, juvenile, circuit, municipal, or tribal court judge or magistrate acting as part of a program team. One of the things that we recently learned is there are retired judges who would like to participate as treatment court judges who are very qualified to act in that role. And so one of the amendments that we would request is that a retired judge be included in that definition to allow them to act as a treatment court judge as part of the treatment court team. The other thing is we are going to be gaining a Chancery Court judge at the beginning of the year. So we have 3 names to the governor right now. He is pondering his choice, but that judge will be seated at the beginning of the year next year, and that is another option for a treatment court judge. And so those 2 amendments to include a retired judge or the Chancery Court judge in that definition of participating judge would be incredibly helpful and give us a little more latitude in finding treatment court judges who could be part of that program team.
So explain to me, I guess I always envisioned Chancery Court judges being a very unique specialty area that doesn't seem to have a lot of crossover with treatment courts. So is the individual that we would select to be a Chancery Court judge really going to have the background to necessarily be of value to the treatment courts?
Mr. Chairman, maybe not, but the option is useful. It's very possible that we could have a judge in that position who does have background in things like behavioral health and could contribute to a treatment court team.
Okay. Further questions? So you're asking for an amendment to this bill draft to further expand the definition of participating judge to include a retired judge and a Chancery Court judge. Where would you suggest that that addition be made?
Mr. Chairman, that's correct. And I would just suggest that in that definition where it lists out district, juvenile, circuit, municipal, or tribal court judge, that you add in retired and Chancery. So it could read, and I am not a bill drafter, I will tell you that, but it could read participating judge means the district, Chancery, juvenile, circuit, municipal, or tribal court judge, or a retired judge or magistrate acting as part of a program team. I am sure there is a more eloquent way to say that, but that would be the gist of the amendment.
Anna, do you have that?
I do, Mr. Chairman.
Okay, do you have a suggestion for where to insert that or how to articulate it?
I think if you just give me leeway to put it in there however I see fit, I think that'll work.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Just a question for Ms. Butler. Without this language in the bill, I realize the intent of the bill, but isn't this already happening where retired judges are filling drug treatment courts? I know it's happening in my county where we just filled a slot.
Ms. Butler?
Mr. Chairman, Representative Rodriguez-Williams, I think it's happening in that one county. What we had to do in that circumstance is we had to use another statute to appoint that judge as a treatment court judge. So there's a statute in Title V that allows the Chief Justice to assign a retired judge to specific cases. So we used that statute in order to assign the judge to the treatment court team. This would just make it much more streamlined.
So, Mr. Chairman, we would suggest that this is your fault. That we, this amendment will, yeah.
Mr. Chairman,
Yes.
I think we could just say participating judge means the district, juvenile, circuit, municipal, retired, chancery, or tribal court judge. I think that would work.
Do that one more time for me.
Participating judge means the district, juvenile, circuit, municipal, retired, chancery, or tribal court judge.
Okay, committee, everybody clear on that amendment? And where are you inserting that language, page and line?
It would be, just give me 1 second.
So, Mr. Chairman, this would be a definition of existing law that would have to be inserted into the bill draft. Mr. Chairman, I did email you that definition moments ago. It would go page 3 after line 21. So it would insert that paragraph 7 that I sent with the definition of participating judge, and then would include the changes that Ms. Johnson has outlined.
Does the language of referring judge need to be changed as well, or is that still limited for?
Referring judge would not need to be changed. A retired judge or a chancery court judge wouldn't be making those sorts of referrals.
So we have a motion to amend, is that correct? On the floor?
We have not moved the bill yet, Mr. Chairman.
Okay. So this is a proposal. All right, thank you. Thank you for keeping me on track, Mr. Question. We won't. Further questions? All right, thank you very much. Anyone else in the room wishing to discuss or present on Working Draft 103, version 12? Anybody on Zoom?
Mr. Chairman, we do have Ms. Somerville online joining us.
Bring Ms. Somerville in, please. Good morning.
Good morning, Mr.
Introduce
Chairman.
yourself and tell us what you want us to hear.
Mr. Chairman, members of the committee, Andy Somerville, Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers, and I apologize that I can't be with you in the room today. Mr. Chairman, I don't have any direct comments towards the bill today. I just wanted to be available if there were any further questions. We feel comfortable with where we've made some suggestions to clean up the language in the bill and are fairly comfortable with where it's at right now.
Thank you for being here today. Any questions for Ms. Somerville? Don't see any. Thank you again for being here to field questions if needed. Anyone else in the room on Zoom? Okay, with that, I'm going to close public comment. Committee, what's your pleasure? Moved the bill by Senator Schuler, second by Representative Chestick. Did I mishear that? Representative Provenza made the motion, seconded by Representative Chestick. Very good. All right. Committee on the bill, any amendments, proposal amendments? Mr. Co-Chairman?
Mr. Chairman, I would move the amendment that we spoke about a few minutes ago, bottom of page 3, insert the amended language to include the Chancery Court judge and retired judge. I think that Anna has that language, and so does Mr. Fuller. So it's conceptual, but I know they'll put it in the right way, in the right place. That would come in right after paragraph 6 at the bottom of page 3. I would move that amendment.
Second? Okay. So we have a motion by the co-chairman, second by Senator Cooper, to make this amendment on the participating judge, expansion of the participating judges identified. Questions, concerns, discussion?
Question.
Representative Craigo.
Thank you, Mr. Chairman. So I have no problem with the retired judge being added to the participating judge list. I just don't know the usefulness, and I'm not sure the logic behind adding the Chancery Court judge to that. I mean, the whole point of creating the Chancery Court is so they can get their job done, which we've set up this whole new branch with whole new subdivision within the branch to do a lot of that stuff. I understand that it's maybe until we get the court busy that there could be some work going that way. I just don't want us to burden the Chancery Court once we get up and running. Once we have the full caseload over there, I don't know. I'm struggling with that one. I don't know if it matters one way or the other right now, but I could see some issues years down the road where that's not a great idea. And you kind of referenced it earlier, Mr. Chairman. So that's my only hesitancy with the amendment. I totally am supportive of retired judges because there's a lot of them that can be helpful in this particular arena, but that I'm not excited about, the other part of it.
Okay. Further discussion? Okay, sensing an urge to vote, all in favor of the amendment, and the amendment does include Chancery Court judges and retired judges. All those in favor say aye.
Aye.
All those opposed, no. No. I think that amendment carries. Further amendments?
Question on the bill.
Question on the bill. Roll call on 0103, version 12. Clarissa?
Mr. Chairman, this is a roll call vote for 25 LSO 103, treatment courts amendments as amended. Senator Case?
Excused.
Senator Cooper?
Aye.
Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Craigo? Representative Haroldson? Mr. Chairman, I don't see him online.
Excused.
Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams? Co-Chairman Landon?
Aye.
Chairman Washut?
Aye.
Mr. Chairman, we have 11 ayes, 1 no, 2 excused.
Thank you both.
Thank you, Chairman Larson. Appreciate that. Thank you. 2 more minutes. She's going to go get the chief. She's going to go get the Chief Justice.
So once again, we're going to stand at ease for about 10 minutes and come back in. Committee, welcome back. So we have a couple of bill drafts before us dealing with the judicial branch. The Chief Justice has stepped away from another meeting to be able to join us, so I think we're going to, would you rather have the bill drafts introduced first, or would it make your comments first, Madam Chief Justice?
Mr. Chairman, members of the committee, I might make a couple comments first and then proceed however you see fit. I wanted to thank you for making time for me. I was here participating by teams in a meeting on the diversion court in Gillette just to follow up on that program and see what modifications might be needed. So I missed your discussion of treatment court, but I really support, or I appreciate your support of the judiciary's running of treatment courts. It's been so important, and we now have a behavioral health person on our staff to kind of oversee both the treatment court management and the mental health diversion programs, which we, as you know, we have one up and running in Gillette. We are working on getting another one here in Natrona County and one in Laramie County. So we're really moving forward on the behavioral health front and appreciate this committee's support on that. Also, I just want to mention that one of the reasons that we are encountering success is because of working across branches. I learned that in Laramie County now, they just did 2 telepsych evaluations in the jail, which is really going to help take some pressure off the state hospital for competency evals. So we have a lot of good things going on, and I just wanted to mention that, not to take up too much of your time. But if you want to talk about these, the other reason I'm here, honestly, this isn't, these 2 bills, certainly Elisa Butler could handle them, but this might be the last time I get to see this committee in this form, and I wanted to tell you all how much I've appreciated working with you in the last couple of years. So thanks.
Well, thank you, and we're very glad you're here. Why don't we go ahead and walk through the bill drafts? Mr. Co-Chairman, do you have any comments first, and then we'll go to the bill draft?
No, I think let's hear about these 2 bills, and I know the Chief Justice has to get back to what she was up to, and let's move on so that in case there's any further comments. So.
Yes, Froeller.
Okay, Mr. Chairman, 25 LSO 285, draft 0.413-01 in the online immunity materials, Chancery Court Judges, District and Circuit Court Assistants. This bill draft would authorize a Chancery Court judge to be assigned to preside over cases and proceedings in circuit courts and district courts. And then the draft would also authorize retired Chancery Court judges to provide judicial service. So page 2, line 5, this is a provision concerning retired judges. It provides that any Chancery Court judge who is retired may be called upon at the request of a district court judge, and then on line 10, a new addition, or circuit court judge may be assigned to a service on any court. Then on page 3, line 9, and 53112A, this would provide that a judge of the district court may assign to, and the addition on line 9, a Chancery Court judge any case or proceeding within the jurisdiction of the district court. Page 3, line 13, the effect of that stricken language would provide that consent from each plaintiff and each defendant in a civil action, regardless of the amount at controversy, consent in basically all cases assigned would be required. Then moving on to page 4, line 5, this provides that a circuit court judge may assign to, and the addition of, so it would be a circuit court judge may assign to a Chancery Court judge any case or proceeding within the circuit court's jurisdiction. Page 4, line 21, this is in the statutes for the Chancery Court judge and would provide that a judge of the Chancery Court may hear any case or proceeding that's assigned to the Chancery Court by a district court or a circuit court. Then finally, page 5, line 4, this is a new subsection that would provide, in essence, that the expenses of a Chancery Court judge who is assigned to service on a district court or circuit court, that those expenses would be charged to the relevant circuit court or district court. With that, Mr. Chairman, happy to answer questions on this bill draft.
Questions for Mr. Fuller? Seeing none, thank you, Mr. Fuller. Committee. Any questions for our witnesses? Do you have any comments, Chief Justice or Ms. Butler?
Mr. Chairman, the general reason for this bill is, but first of all, we're going to have a new Chancery Court judge, full-time judge, starting January 1st. You'll recall that the legislature in 2019 established the Chancery Court. We've had 2 district court judges filling in as Chancery Court judges, and now we have enough of a caseload to almost justify a full-time Chancery Court judge. But it's not going to be necessarily a full-time job right away. And so what we're trying to accomplish here basically is to allow the flexibility for that judge to help out in other courts. We do that already between the circuit courts and district courts. We do it also with using retired judges to help out where needed. And this would just allow us to do the same thing with the Chancery Court judge.
Okay, questions for the Chief? Senator Schuler.
Thank you, Mr. Chairman. Just a couple questions, Chief Justice. First of all, thanks for being here. It's good to see you. The one thing that kind of gave me some pause is on page 2, where they talk about the assignments of those retired judges. And I know it's with their consent, but it seems to me that it could jeopardize their retirement plans. Is that, I mean, have you guys worked that all out so that it doesn't, is there a certain amount that they can make without jeopardizing, or how does that work?
Madam Chief Justice.
Mr. Chairman, Senator Schuler, there is some provision, and I don't know exactly how it works, but our retired judges have to wait 30 days, first of all, otherwise it messes up their retirement. But after that, we are able to pay them without jeopardizing their retirement, and I'm not sure why. Do you know? No.
Okay. And the second question, if I could, a follow-up? Thank you, Mr. Chairman. Do we have a rather large pool of retired judges that you might be able to seek for some of these retired positions, possibly?
Mr. Chairman, Senator Schuler, we do have a decent pool of retired judges. Right now, for example, Judge Sullen's a retired district court judge here in Natrona County, and Justice Davis have helped out around the state. I find the longer they're retired, the harder it is to persuade them to come back to work.
Further questions? Is that Representative Jennings?
Thank you, Mr. Chairman. Chief, I have a little bit of a question on, so currently we share judges back and forth, and is this the same methodology that you'd use that, say, they're shared across to a district court or something like that, or to the circuit court? Then do you pull the money out currently out of, say, the circuit court, say, wherever you're loaning them to? Is that the same methodology that is used currently?
Chief?
Mr. Chairman, Representative Jennings, we don't actually do a lot of crossing across from circuit to district court at this time, or from Supreme Court. We use district court judges in the Supreme Court when a justice is recused. But there's no money transferred other than travel maybe, because they're doing their jobs. They're on the payroll. They're just spending a day in our court instead of theirs.
Thank you, Mr. Chairman. So if that's the case, then why here do we now want to pull it out of district court or circuit court? If we don't do it now, if they're just doing their job anyway, why now do we want to change that?
Mr. Chairman, Representative Jennings, I think you're probably looking at this provision on page 5 about the expenses, and that's just the cost, the travel expenses and that kind of thing. They're not getting, nobody's getting remuneration for that service other than the retired judges.
Mr. Chairman, so Mr. Chairman, if I may, in response to Representative Jennings' questions, that language does come from an existing statute. It's 5-3-109. And that section reads about the same, providing for the expenses of judges while acting in another district or circuit.
Thank you, Mr. Chairman. Your Honor, I'm thinking about the age requirement to retire, and just curious what your thoughts are about how that comes into play if this bill were to pass, and we allow retired judges to come back and serve and fill these vacant positions.
Mr. Co-Chair, Representative Rodriguez-Williams, this bill really doesn't do the authorizing for retired judges. It's mostly addressing Chancery Court. We already have a statute in the books, I believe it's 52106F, which authorizes the use of retired judges.
Representative Jennings.
Thank you, Mr. Chairman. I guess my question will go to Mr. Fuller or Chief Justice. So on line 8, it addresses what the Chief Justice said, that it covers the traveling expenses, but then the next part of that sentence says, and the judge's expenses while holding court. So it would clearly reach out a little further than that. So does the statute that Mr. Fuller quoted, or is what Chief Justice is saying? Because it looks to me like we're broadening the scope of where how much money we're able to pull from one court to put into whoever's filling in.
Mr. Fuller?
Sure, I'm just trying to get a feel for that, Mr. Chairman.
Mr. Chairman, Representative Jennings, 53109 says the expenses of any district judge holding court in any district or any circuit court, including his traveling expenses to and from said district or circuit, and his expenses while holding court therein. So that holding court language is in 53109 as well.
So it's not broadening anything, it's just...
Mr. Chairman, I believe it's the same language. I cleaned it up a bit. I didn't use it therein or what have you, but I think it covers the same concept.
Chief, I'll give you a chance to comment.
Mr. Co-Chair, the only thing I'd add is, for example, if a district court judge travels to another district to cover that district's case, what this provides and what it has provided historically is that if they need a motel room or mileage or they're paying their court reporter, those expenses are reimbursed out of the host district's budget.
Thank you, Mr. Chairman. I have a question about maybe, do we have a potential conflict now, and if we adopt this bill, do we have a conflict with 513-115, which is not being amended by this bill? 513-115 sets up the purpose of the Chancery Court and the jurisdiction of the Chancery Court, and it's to handle business-related cases where they exceed $50,000. And we've taken that $50,000 out on line 15 and 16 on page 3, but that's in section 53112. But we still have the $50,000 jurisdictional limit in 513-115. I guess I'm kind of confused as to what kinds of cases would a judge of the district court assign. Is the $50,000 requirement still there, or is 115 going to make it? Is there a conflict here? I'm just not understanding what kinds of cases are supposed to be assigned to the Chancery Court that is enabled by this bill. Do we have to change something else, I guess?
Chief, is there a conflict?
Mr. Chair, Representative Chestic, I don't believe there is a conflict. I think 513-115 establishes the jurisdiction of the Chancery Court, so there's a minimum amount of $50,000 there. These amendments allow the judge to go work in other courts. And so the jurisdictional requirement for Chancery Court really isn't applicable. Say that judge is doing district court work in a case that doesn't have that jurisdictional amount.
So essentially, when a judge is assigned to a circuit court or a district court under this new bill, they are no longer acting as a Chancery Court judge, they're acting as a district court or a circuit court judge. Is that diluting the power of I understand you're trying to make sure there's enough workload, enough work for the judge to work full time. I worry about whether we are diluting the purpose of the court. It's a specialized court, and now they can handle any kind of case, whether it's business or not related.
Mr. Chairman, Representative Chestic, I think that's similar to your previous question. So the Chancery Court will still be a specialized court for the statutory purposes. And the judge, when he's acting as the Chancery Court judge, will be doing those cases. But this would allow the judge to act in different capacities when necessary and when he's available.
Further questions? Representative Jennings.
Thank you, Mr. Chairman. So Chief Justice, who sets the prioritization through this legislation? Does the Supreme Court then say, look, Chancery Court, you could, you might have to postpone your Chancery Court hearings and go sit in a district court for 2 weeks? I mean, who makes that judgment call? Who prioritizes the Chancery Court's time?
Chief?
Mr. Co-Chair, Representative Jennings, right now, the way it happens, for example, if district court judges help each other, which they do regularly, if either there's a conflict or a heavy docket, of course, a judge who's already buried isn't going to offer to go help his brother in another district. It's just common sense, right? That we're going to utilize the resources where they're needed. So the Chancery Court judge, that's his number one, that's his day job, right? And if the Chancery Court judge is full, then that person will not be asked to go help someone else out. Now, to answer your question, who sets that? We have an executive committee of the Wyoming Judicial Council right now that makes decisions. For example, when we get a request from a judge for a retired judge to help them out. And there are criteria for when that will be allocated and who might be available to do it. So it would be the executive committee that would make that decision. And I have faith that the executive committee would exercise its common sense and remember that the Chancery Court judge's priority is Chancery Court work.
So, Chief, my question would be, if we don't pass this law and your Chancery Court judge has a gap in the docket, so to speak, not much work for a certain period of time, that Chancery Court judge is twiddling thumbs while we wait for work? And is this really intended just to make the best use of resources that are being paid for by the taxpayers?
Mr. Co-Chair, that's exactly right. That's the point of this. And hopefully, within a year or two, the Chancery Court judge will be busy full-time and this won't be necessary. But we don't want him twiddling his thumbs.
Further questions? Thank you both. All right, with regards, committee, to Yeah, oh yeah. Anybody else in the room? I guess we'll give, anybody else in the room wishing to testify about 0285? 0285, anybody in the room? Anybody on Zoom? All right, now I'm going to close public testimony. Committee, your pleasure. Moved by co-chairman, second by Senator Schuler. Discussion on the bill. Any amendments? Sensing an urge to vote. Clarissa, please call the roll.
Mr. Chairman, this is a roll call vote for 25 LSO 285, Chancery Court Judges, District and Circuit Court Assistants. Senator Case? Senator Cooper? Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Craico? Representative Haroldson?
Aye.
Representative Jennings? Can you repeat, please? No. Representative Nemec? Representative Oakley? Representative Provenza?
Aye.
Representative Rodriguez-Williams? Co-Chairman Landon?
Aye.
Chairman Washit?
Aye.
Mr. Chairman, we have 12 ayes, 1 no, 1 excused.
Thank you very much. Takes us now to 0286. 0286, Mr. Fuller?
Yep, Mr. Chairman, working draft 0.5, this is 13-02 in the online meeting materials. This bill draft increases the court automation fee in civil cases, criminal cases, probate cases, and appeals by $10. So on page 2, lines 6 and 7, this is the statute concerning probate matters. Fee is increased from $40 to $50. Page 2, line 20, the statute concerning appeals, the court automation fee increased from $55 to $65. Page 3, lines 16 and 17, this is civil matters in district court. The change on page 3, lines 16 and 17 is a conforming amendment based on the way that paragraph is drafted. And then page 3, line 20 and 21 increases the court automation fee from $40 to $50. Then on page 4, line 4, for transcripts and cases that are appealed, a $10 increase on line 7 and 8 from $40 to $50. Page 4, line 15, concerning appeals from circuit court to district court, the court automation fee on lines 21 and 22 increased from 40 to 50. Page 5, lines 14 and 15, this is a statute concerning municipal courts. By ordinance, the city or town may prescribe a court automation fee that is increased from $40 to $50. Page 5, lines 22 and 23, this is civil matters in circuit court, an increase from $40 to $50. Page 6, line 15, this is the Chancery Court, the court automation fee increased from $100 to $110. Page 7, line 9, this is the conviction of a felony, court automation fee from $40 to $50. Then page 8, line 7 and 8, this is misdemeanor convictions, again, increase from $40 to $50. Applicability on page 8, line 19, this would apply to cases and appeals filed on and after July 1, 2025, and that's the effective date. Happy to answer questions, Mr. Chairman.
So, Mr. Fuller, we're on working draft .5. I think my paper copy is .4, sorry.
So, Mr. Chairman, that's correct. It should be .5. There should be, those were provided in the packet, so they should be underneath your materials, but we put those out yesterday. And Mr. Chairman, my apologies for not catching that.
Thank you. All right. Chief, Ms. Butler, comments on this draft?
Mr. Co-Chair, this draft is basically, even though has various amendments in it, it's to raise the filing fee by $10 to contribute to the Judicial Systems Automation account. So the reason that we're asking for that is because this account is established by 52120 for the purchase, maintenance, and operation of computer hardware, software, and we also use the JSA account for, I believe, 13 salaries of our IT staff. That fund is projected to go into the hole by fiscal year 2030, 31 or 32 at the rate that we're going. And that's because of a couple of things. I think you're all familiar with the increased cost of IT. We're conducting continuous hardware refreshes in all of our courts and also staying up on all the software and security needs. So in order to get ahead of this fund depletion, we are asking for this $10 increase in the filing fee. We have a really complicated breakdown. The total district court filing fee right now, I believe, is $160. That goes to various places. Some of it goes to the county, some goes to the general fund, some to JSA. $10 goes to Equal Justice Wyoming. This would increase the JSA amount from $40 to $50. I can tell you more about this, but I would probably just stand for questions. One thing I'll say is I do know that my friend Director Schmidt is going to speak against this because of the impact it would have on DFS and the child custody filings. That has been an issue in the past, and I sympathize. We've dealt with that either by appropriating the necessary funds to DFS, or in one case at least, we've held off on increasing the amount for governmental entities. So while I recognize that this creates a problem for DFS, I think it's something we can deal with. And I'd stand for any questions.
Question. Representative Oakley.
Thank you, Mr. Chairman. Chief Justice Fox, you mentioned the general fund, and you also said it was maybe a complicated formula or something, but do you know the number or the percentage that goes to the general fund by chance?
Mr. Co-Chair, Representative Oakley, I do, or at least Elisa does.
Good enough.
Mr. Chairman, it is a little bit complex because of the fees go different places depending on whether it's in circuit court or district court. So for the circuit court, a number of those fees do go to the general fund, and we can provide you with a handout. But like let me just look through. For some of these fees also go to the local county. And so you'll see that throughout. I think, Mr. Chairman, rather than going through this entire lovely little spreadsheet, what I would like to do is just provide it to the members. And then you all can take a look at where things land. We'll email this.
Mr. Chairman, just to jump in real quickly, committee, while we get things handed out so everyone has a complete breakdown of where our money goes on these fees, I wanted to just acknowledge that the good representative from Cheyenne visited with the Chief Justice about the same time that the chairman did on this particular issue and was good enough to get this in motion. And that's why you have a sponsorship on the bills today, but it's really for our consideration as a committee, and we thought that was entirely appropriate. So I just wanted to throw that out there and show a little appreciation for the representative for getting this underway so that we could consider it. Thank you, Mr. Chairman.
So Representative Oakley, are you good? Further questions? So, just so we're completely clear, we just raised fees a year or two ago for probate. Can you talk about the difference here and why we're back? Is it different accounts, revenue streams, or whatever? Could you just help us understand all that?
Mr. Co-Chair, yes. Last year, or in the '23 session, there was an increase of $40, which went to the counties, because I believe the district court clerks were the ones who were really pushing for that increase. The adjustment for probate was really more to get the probate filing fee in line with the rest of the civil filing fees. Primarily, because for some reason historically those had gotten out of whack. And with our new e-filing system, it was really difficult to process those different charges, but I don't know that that amount was super significant. And I'm looking at Elisa to correct me if I'm wrong.
Mr. Chairman, I don't remember the exact amount. I do know that if you would like me to look that up, I can, or I would imagine one of the district court clerks who are standing behind me could answer that question as well.
Further questions from the committee? Seeing none, I do suspect there's others in the room who wish to testify, and Director Schmidt.
Thank you.
Madam Chief Justice, you might want to slide down away from.
Thank you, Mr. Chairman. Members of the committee, I just wanted to give forewarning that there will be a fiscal note attached to this per Representative Rodriguez-Williams' question earlier. Every time that there is an increase in filing fees, it affects our child support program. And we file a lot of cases in circuit court. So this is a conversation I think we've had with this committee before in regard to some of the other increases, but it does put us in a difficult situation with general fund. The child support program is matched 65% to 35%, so 65% federal dollars, 35% general fund dollars, but we have to have that general fund in our account in order to pull down the federal dollars. So it kind of gives us a catch-22. I certainly can appreciate the situation that the Supreme Court finds itself around technology after having to deal with a lot of IT systems. And certainly I gave fair warning to the chief that this was going to happen.
Questions for the director? Senator Schuler.
Thank you, Mr. Chairman. Yesterday, we worked a little bit on some of the monetary things that are on the books that haven't been changed for many, many years. Do you have any idea when the last time was that these fees were imparted?
Chief?
Mr. Co-Chair, Senator Schuler, we have, the filing fee has been raised pretty regularly over the years. The fee for the judicial system automation hasn't been raised for quite a while. I can't remember exactly how long.
Thank you.
Further questions? Okay. Thank you, Director. Others in the room wishing to testify with regards to 0286? None of the court clerks? No? Ms. Butler coming back up? Sounds like she might have an answer to a question.
Mr. Chairman, Senator Schuler, we do have a history on that second handout at the very top of the increase in just the JSA fee. So this does not account for what the total filing fee is. It's just the increase that has been accounted for in that JSA. So there's a full history there for you to look through. It has been amended quite a bit over the years to accommodate the increased costs of technology for the branch. And then to the other question, I believe, Mr. Chairman, it was the last increase for just that filing fee, the probate filing fee I think we were talking about was $40, I believe.
All right. So I guess my question is this for the two of you. Are the fees the only way to infuse additional revenue into this account? Is it possible to ask for a direct appropriation from the JAC to infuse additional revenues to keep your fund afloat beyond 2030?
Mr. Co-Chair, we would take whatever source of funds we could get. The truth is that I expect that it's more palatable to the legislature for us to have these non-general fund revenue sources. However, we did a few years ago approach the legislature to try to float the idea of getting our salaried people out of the JSA fund where they really don't belong and have them be general fund. I would certainly welcome that. However, I'm just not thinking you would.
Chief, if we were able to do that and fund those salaries out of your personnel line items, would the fees coming into this account then be sufficient to cover your IT needs if the salaries were put where they belong?
Mr. Co-Chair, let me look at this real quick. I think so. Because, let's see, so for fiscal year 2025, salaries are $1.8 million, whereas software and hardware, and I'm using broad numbers, right? Software, hardware, and other miscellaneous would be nearly 3 million. So yes, if you took the $1.8 million out of there, we could probably go a long ways with the existing JSA fund.
Thank you. Further questions? Again, anyone else in the room wishing to testify on 0286? Anybody on Zoom? All right, we're going to close public comment. Committee, what's your preference?
I'll move the bill.
Moved by co-chairman, second by Representative Chestick. Discussion on the bill, Mr. Co-chairman.
Mr. Chairman, thank you. You know, committee, this one really kind of just boils down to philosophy on the part of the legislature. We set this up a few years ago to assist in trying to get our courts up to speed out across the land. I think it's worked really well. We've gained a lot of ground on several fronts. I've heard from attorneys in my community that we're doing much, much better. And this really is whether or not we want to support that effort through the fees, or if we want to force the judicial branch to go through the appropriations committee to try to get enough funding to put new screens in the courtroom or new hardware and software. So, you know, through the years, I've always been pretty supportive of efforts to make things self-sustaining. That's what this does. Now, I do have a question as to whether or not I would think that a bill like this would go directly to the Appropriations Committee anyway, if we were to forward it. So, but I wonder about a fiscal note, and I wonder about language that would be included into the referencing the budget needs that are going to be that are going to arise in the Department of Family Services. So other than that, it's really a vote as to whether or not we want to fund the technology efforts of the judicial branch through a fee process, or if we want to try to battle every other year in the Appropriations Committee, so.
Representative Jennings.
Thank you, Mr. Chairman. So on the handout, page 1, I agree with the co-chairman there that this is a policy decision. I look at that and I say, it starts in 25. We anticipate refreshing 7 courts per year. The only difference is that the refresh will span 10 years instead of 7. So it doesn't double or it doesn't go up 50%, but it goes up substantially. It goes from 7 years of refreshing it. And do we think that 7 years is acceptable, or do we want to go 10? So it's not that the money won't continue coming in at $40. It just won't come in as fast, and you won't refresh as many courtrooms as fast.
Thank you, Mr. Chairman. I'm going to let my chief here kick back in again, and this is pretty much a simple pay me now or pay me later deal. Here's an opportunity to make this system more self-sustainable. I think that's somewhere we need to go as we continue to address budget issues. I think if we can defer anything from the general fund and the budget, that's something we need to be looking at. Thank you.
Further comment, questions? I guess I'm still a little bothered by the fact that we're paying ongoing salaries out of this special revenue approach. And I'm sure it's not the only example of doing that within our budget, that we probably do that elsewhere. But it would seem to me that it'd be appropriate that those salaries, because of their ongoing nature, we're going to have IT professionals working within the judicial branch forever, right? That those go into the personnel line items where they actually could be funded with general fund revenue, and then the fee revenues would be adequate to cover the cost of the IT expenses. But it does ask us to put trust in the JAC process that might actually occur. And I guess I worry whether either approach is politically likely in the short term. But it also strikes me that the fund won't be in the hole tomorrow. That maybe we do have some time as the legislature to work with our counterparts in the Appropriations Committee and see what the appetite might be to move some of these costs that are presently coming out of this special revenue account into the regular line items account. So I don't know. I'm not optimistic that this bill is going to have legs in January, and that gives me some pause as to what might be the best approach.
So, well stated, Mr. Chairman. I appreciate that. That might give us enough cause right there to send forward. If nothing else, this is an alert, to what's going to be a new Appropriations Committee. The fact that in a handful of years, this is not going to be actuarially sound. I'll go back to what I said yesterday. We don't proact very often in the legislature. We usually react. And so if we want to run that out of money and get to that point, we can certainly do that. It just, I kind of commend the Chief Justice for getting out in front of something and saying, look, we're just projecting this out, and it doesn't project very far into the future before we're going to need to do something about it. So it's kind of pick your poison. I would probably, and today I'll probably support this just to send forward to that appropriations committee, look, we've got an issue. And that will give us as former chairman of this committee the opportunity to go in front of the appropriations committee and say, you know, what you might want to consider is putting those salaried positions where they belong. And then this fund isn't going to need our help. So, but that's me. Everyone can vote their conscience.
Okay. Sensing an urge, Representative Jennings?
Yeah, I just want to kind of point out again, that it's not that this fund goes to zero, because these fees are always coming in. It's how quick does the committee want to refresh the IT in the courtrooms? Every 7 years or every 10 years? Sure, I'd rather do it in every 5 or 3 or 2, but somewhere there's a place where there's a waste, and that's the policy decision is, do we want to do it at 7 years is the projection. That's what they'd like to do. But if we don't do this, I mean, they can come and ask for all of the money at once. I mean, it's not an either or. It's just a question of the time that the courts get refreshed, IT-wise. So, and our constituents are going to pay this cost. People that are going to court are going to pay it. So, thank you, Mr. Chairman.
Right. So I guess that's the question before us. If we move these things into the general fund, then all the taxpayers of Wyoming share in the cost of those personnel expenses. If we leave it in the special revenue account, then the users of the court system, a much smaller population group, bear the costs. And, but you're right, you know, if we only replaced our computers every 20 years, we might still be using black and white monitors with DOS, but, you know, we'd save some money. But that frankly, you know, is one way to, you know, stretch the dollars. If you don't replace your technology as often, you get, but there are probably other inefficiencies and challenges that come along with that. And we've all had computers that no longer support the software, the latest updates in the software. So there's practical realities as well. So with that, no more motions. No, we got a question on the bill. Clarissa, you want to call the roll?
Mr. Chairman, this is a roll call vote for 25 LSO 286, court automation fee amendments. Senator Case? Senator Cooper? Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Crago? Representative Haroldson?
No.
Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams? Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 9 ayes, 4 noes, 1 excused.
Well, I think that takes us to the end of the stack, Mr. Co-Chairman.
Mr. Co-Chairman, before the Chief Justice makes her way back to other things that she's got going today, I wanted to thank you for the opportunity to listen and learn and follow your advice over the last couple of years. It's been a pleasure. I hope I run into you in the mountains one of these days soon. And I'm kind of sad about the fact that you're coming up on a retirement thing. So congratulations on that front, but that's going to be our loss. And but anyway, it's been a pleasure the last 2 years, Madam Chief Justice, and I wish you the very best. Can't wait to see you in January, February, but thanks.
Well, thank you, Mr. Co-Chair, and all of you, really. It's been my pleasure to work with you. We're all, even when we disagree, even when I disagree with the director there, we're all working for the same thing, which is the good of the state of Wyoming. And I don't know how many of you know, Senator Landon and I have a Du Bois connection. I'll see you on the East Fork.
Okay, so thank you, Madam Chief Justice. Let's have Brian kind of give us a rundown on what we've accomplished over this interim and at least over these last 2 days.
Yep. So, Mr. Chairman, at this meeting, the committee voted to sponsor the following bills: 25 LSO 0002, removal of residential property, removal of unlawful occupant; 25 LSO 131, the use of fraudulent documents prohibited; 25 LSO 124, restoration of right amendments; 25 LSO 282, negligent investigations, liability; 25 LSO 130, governmental claims, maximum liability amounts. Upon reconsideration, the committee sponsored 25 LSO 283, permanent protection orders; 25 LSO 0004, Department of Family Services confidentiality; 25 LSO 103, treatment courts amendments; 25 LSO 285, Chancery judge assignment to circuit and district court; 25 LSO 286, court automation fee. Mr. Chairman, the committee voted to indefinitely table 25 LSO 281, which was the deadline for peace officer certification and basic training. And then, Mr. Chairman, from September, there were 6 bills that the committee voted to sponsor. 2, 3. And I have 10 from this meeting as well, so that'd be a total of 16 bills. And Mr. Chairman, I can run through those 6 bills that the committee voted to sponsor in September if you wish. Okay, so from September, 25 LSO 121, protection order amendments; 25 LSO 122, protection orders effective during appeal or review; 25 LSO 123, disclosure of sensitive information, law enforcement; 25 LSO 128, states' right of appeal in criminal cases; 25 LSO 129, settlement agreements for minors, parental authorization; and 25 LSO 218, municipal courts, maximum penalties.
A lot of work, committee. More bill drafts than I anticipated at the start of the interim, but a lot of work, a lot of effort, and we'll see how things flesh out in January. I do want to say thank you for that, Brian, but also in addition to that, I'd like to recognize Director Shannon. I saw on the news where 60 or so inmates have been returned to Wyoming because we've got some staffing improvements within the department. Commend you for that, we're retaining more employees, and that's a very positive development. And bringing those inmates back to Wyoming is a good thing for their families. Many of those are Wyoming people who have families in our state, and so being incarcerated out of state is an impact on those families. And so thank you for all your work on that. Mr. Co-Chairman.
Thank you, Mr. Chairman. So we come to the end of things, committee. It's been a pleasure for the last 2 years to work with all of you. I said when I gavelled us in on our first meeting 2 years ago that it was kind of ironic that I was serving as your chairman because I'd really never been in a courtroom before. But we made our way through it, and it was all because of you, and I've learned so much from each of you, and it's been a real pleasure. I wanted to thank Senator Furphy. He's streaming in today, so I regret that we didn't get to go out and just blow the lights out of the Beacon Club last night, Senator Furphy. You know, we'd have gone out and rampaged the town if he'd have been here. But Senator Furphy is retiring, and so I hope that you'll all join me in thanking Senator Furphy for his work in the House and in the Senate, and we wish you the very best, Senator. Thank you for everything you've done. Do you have any words of wisdom, Senator?
Well, it's been a learning experience for me because, like you, Mr. Landon, or Chairman Landon, I have not really been involved in the judicial process. So I've learned a lot, but I've enjoyed meeting all of you that are on the committee. I want to say my replacement, you're going to like him. Gary Crum is replacing me. He's my neighbor. And most importantly, he's a former banker. So yeah, he'll fit in with you guys very much. So thank you, especially Chairman Landon. You and I have served on a lot of committees over the years. So thank you for all your hard work. So, all right, that's enough. Thank you.
Thank you, Senator. And Mr. Co-Chairman, we have a couple others that will be tipping their Stetsons and riding off westward. I want to recognize all of the time and effort put in by Representative Jennings. And I hope that we will see it along the trail still. But I want to thank you. I want to thank Representative Nemec. We will miss you guys. We don't have to vote the same way to become friends through this whole process. And so I want to wish you both the very best and congratulate you. So.
Any parting comments from either of you?
Well, and I was going to say, finally, I want to recognize someone else, and that's Representative Oakley. I've maybe learned the most from you on this committee, by the way, and we're gonna miss you. And we obviously wish you, along with Representative Nemec, Representative Jennings, all three of you. So let's get started. I'd like to hear from each one of them.
Representative Jennings.
Well, I've enjoyed Judiciary several times in my career, and I've liked that, especially the voting no. It's one of my favorites. And so, yeah, we'll be around. We'll still see people. So thanks a lot.
Representative Nemec.
Thank you, Mr. Chairman. I want to thank all of you because I learned so much on this committee. And I'm not much for words, so I'll just leave it at that. But thank you.
Representative Oakley.
Thank you, Mr. Chairman, both of you. Thank you for your leadership in this committee. It's been great. I knew this was going to, you should have done it to me. I just want to say what an honor it's been to be on this committee and work with all you. What other state would you be, working hand in hand with your Chief Justice and the director of the director of every agency, and getting to know you all and really doing some good work. And I appreciate all of you. I appreciate this committee. Thank you all.
Thank you, Mr. Chairman, for giving me that opportunity to.
Those parting comments just remind us as how much our members put their hearts and souls into these responsibilities and the honor of serving in the legislature. As I took a few minutes just looking back over the Judiciary Committee of the 67th and some of the big topics that we dealt with, Chancery Court, cold case database, controlled substances, Delta 8, DFS and law enforcement cross-reporting, emergency adult protection, governmental claims, guardianships and conservatorships, homeland security information sharing, medical examiners, municipal court penalties, guardian ad litem, peace officer records and posts, which peace officer training, presumptive child support payments, protecting our judges and courthouse security, restoration of gun rights amendments. We looked at the rural attorney situation that we have developing in Wyoming, sex offenders, squatters, state park rangers and their retirement, states' rights of appeal and criminal actions, treatment courts transferring from Department of Health into the judicial branch. Remember how much fun we had with drones and drone trespass, right? The Uniform Child Abduction Act, Uniform Child Abduction Prevention Act. You know, 9 of our bills from this committee became law in the 2024 budget session. 13 of our bills became law in the 2013 or 2023 general session. And these are just committee bills. And you think about all of the individual bills, you know, dealing with court reporters and so many other things that individual members have brought that come before this committee. And I think back to taking our tour of the Weatherby manufacturing facility and the girls' school up in Sheridan. The DFS gave us a tour there, and we toured the Natrona County Jail and the Townsend Justice Center downtown, look at court security arrangements. And I'm just impressed. This committee is a hardworking committee. I remember how many times we were meeting at 7 o'clock in the morning when our counterparts were still, you know, having a hot breakfast. And, you know, we did that regularly throughout the session. And just tip of the hat, committee. I am very proud of all of you. And you know, as the co-chairman said, we don't always vote the same, but that doesn't stop me from having tremendous respect for each and every one of you. And so thank you. Mr. Fuller, anything from the staff?
Yeah, Mr. Chairman, nothing from our end.